Let me tell you 60 mistakes this criminal defence solicitor made in episode 1 of the hit Netflix show Adolescence, part of your legal training as a criminal defence solicitor. What not to do, because this criminal defence solicitor was a joke and treated like one by the police. Spoilers ahead. And for those who haven't watched this riveting series, the show centres on the aftermath of a young girl who is M and the rest of her classmate, a very young looking 13-year-old boy called Jamie, played by an exceptional actor, and the unfolding drama of how his parents are forced to confront their worst nightmare, their adolescent son accused of a brutal crime. Episode 1 follows the search of Jamie's home, Jamie's arrest and detention, Jamie's conversations with his father, who's acting as his appropriate adult at the police station, Jamie being strip searched, Jamie's meeting with his defence solicitor, Paul Barlow, and Jamie's police interview. So here are 16 mistakes Jamie's defence solicitor makes when acting for Jamie. 1. The criminal defence solicitor introduces himself to Jamie's family as Paul Barlow of Story and French, but fails to say this. Mr. and Mrs. Miller, as a suspect of the crime, your son at the police station has a right to free and independent legal advice. I work for Jamie, not the police. This means there is no cost to you or your son in providing legal advice at the police station, and I am completely independent of the police. What the defence solicitor does right is to tell the family the process which is involved in being police briefed by the arresting officers prior to any police interview taking place. 2. The next point the criminal defence solicitor gets wrong and is a mistake is his response to any complaints the family have so far. Mum and Dad, Mr. and Mrs. Miller, mentioned tearing the house apart, the police dawn raid, the use of guns on a 13-year-old, smashing the door in and wrecking the house. In response, the criminal defence solicitor says quite blasé, when a violent death takes place, that's the name of the game, as if this is normal police procedure, and then says something like, the question is whether the actions of the police were proportionate or not. This is wrong and incomplete advice given to the family. Mr. and Mrs. Miller, actions of the police to enter without consent, use force to gain entry, use armed officers to search through the house and rooms, and the seizure of any items must have a legal basis and be necessary and proportionate, must be justified on a factual basis. The attitude of this criminal defence solicitor was pretty poor and dismissive of the family's complaint. He should have said, Mr. and Mrs. Miller, I'm going to address this with the police. Tell me more. 3. Defence solicitor fails to explain the role of the appropriate adult. When informed by the father, Mr. Miller, that he has been asked by the police to be the appropriate adult for his son, Jamie. In reply, the defence solicitor says probably better for the father to be appropriate adult to keep him, that is Jamie, so-called calm. What? Is that it? And because the defence solicitor doesn't explain clearly what the role of the appropriate adult is, the father, the appropriate adult, makes some fundamental mistakes during Jamie's police interview, which is mentioned later. What the defence solicitor should have said to the father, Mr. Miller, is this. Mr. Miller, you have a very important role to safeguard the rights, entitlement and welfare of your son, Jamie, to support and advise and assist your son, to observe whether the police are acting properly towards your son, to assist your son to communicate with the police, and to help your son understand his rights. You, Mr. Miller, have an active, not passive role. Speak up if you believe the police are mistreating your son, but don't answer for your son and follow my legal advice. 4. During the police briefing, the criminal defence solicitor was unprofessional to allow the investigating officer to call him by his first name, Paul, even though the defence solicitor called the investigating officer D.I. Bascom. If you are ever a suspect and ever have a solicitor who allows police officers to call them by their first name, change your solicitor fast. Don't trust them, because they will be unwilling to challenge the police, as seen by this joker who's treated as a joke by the police, being called a prick. And if you are a solicitor, stay professional. Insist the police call you by your surname. 5. During the same police briefing, the criminal defence solicitor failed dismally to challenge the interviewing officers in their failure to provide proper disclosure. Officers, what is the allegation being made against my client? Officer, what evidence do you have? Officer, why has my client been arrested? Officer, what questions will you be asking my client about any posting he's made, his internet search history if that is the issue. Officer, do you have any CCTV footage? The police need to provide proper disclosure as per Code C, the police rulebook, so a solicitor can properly advise their client, in this case Jamie. This defence solicitor should also have questioned the legality of any forthcoming strip search. Officer, why is it necessary to carry out a strip search? None of this was done. This would have put the police on notice that they're dealing with a criminal defence solicitor who's pushing to treat their client fairly and that no surprises should be made, like disclosing evidence during the police interview. And the defence solicitor fails to make a complaint of unprofessional conduct when verbally abused by a police officer. The criminal defence solicitor was like a doormat waiting to be walked over. 6. It was not legally necessary for Jamie's defence lawyer to be in the room when Jamie was being strip searched. And in fact, it was wrong, a mistake, to be in that place when the strip search takes place. Let me explain this one. By law, it is right and proper for the presence of Jamie's father to be present during the strip search, as Jamie's father is the appropriate adult. By law, though, defence lawyers are not legally required to be in the room during a strip search. And what exactly is the point of the defence lawyer being in the room when the strip search is taking place if his back is turned and he couldn't see what was or was not found in the strip search? And to be quite frank, in practice, or my practice at least, I don't want to be in the room when a strip search takes place because I don't want to place myself at risk of becoming a witness for the prosecution in case something is found during the strip search. And as a defence lawyer, I may be called to give evidence at trial to confirm that something was found. That will place me in a very compromising position with my client. And what is this kind of explanation of the role when the criminal defence solicitor meets Jamie for the first time? I'll be advising you today. Wow, thank you, mate. That really does inspire confidence, but it gets worse. 7. During the private meeting with Jamie and his father acting as the appropriate adult, the criminal defence solicitor doesn't explain his role properly. He says some things, my role is to protect you, whatever happened last night. What about saying this? Jamie, let me explain the offence to you of M. Jamie, let me explain what the police say you have done. Jamie, let me explain the evidence the police have told me about. Jamie, let me tell you about what the evidence the police might be withholding from you and might be disclosed during the police interview. Jamie, let me explain how strong the evidence is against you, in my opinion. Jamie, please provide me your account. Let me explain the options to you, Jamie, about whether to talk to the police or to not talk to the police. Jamie, let me give you my advice whether to talk to the police, and let me give you my reasons why I'm giving you that advice. But at the end of the day, Jamie, it's your call whether to talk to the police or not. And do you remember this throwaway remark by the criminal defence solicitor? I'm not here to ask you whether or not you did it or didn't do it, Jamie. Well, actually, mate, you are. Maybe not then and there, but somewhere down the line, you must ask that question to your client, Jamie, so you can work out the strategy, whether this is, and think about this, this is an eventual guilty plea and mitigation at court, or whether this is going to be a not guilty plea and a trial, or whether there's a chance of a no further action for Jamie at the police station. Any strategy is based on knowing what the client's account is, and that doesn't happen. Let's be fair, I did like the idea of the defence solicitor asking Jamie about his favourite subjects to ascertain his level of intelligence and thus ability to understand questions. 8. The advice given to Jamie to say no comment to the police questions about the events of last night, but to answer other police questions was totally wrong. Jamie even says whether that means to say no comment to every question, and the defence solicitor says, no, that won't go down well. Who cares whether that will go down well with the police? What matters is whether it will go down well with any court if it gets that far. What an incredibly poor reason to give a no comment to some questions and to others unrelated to the event to answer police questions. Jamie should have been advised like this. Jamie, every single police question that the police will ask you has a point to them, whether that is about your school reports, who your friends are, your posts, what you were wearing, footwear you were wearing, any romances you have, and your movements on the day of the event. Do you understand? In fact, the best advice the defence solicitor should have given Jamie was not to say no comment to all the police questions, but instead to stay silent as soon as Jamie walked through the police interview door. You see, the more vulnerable a suspect is, the more important it is to stay silent to prevent the risk of saying something that will damage the client's interest. In this case, Jamie's very vulnerable to police suggestibility, taking account how clever he is supposed to be. A suspect inexperienced in a police interview, a vulnerable suspect simply by his age, 13, a suspect suggestible to police questioning, a suspect who is at risk of making incriminating and inconsistent comments, and a youth suspect who is likely to quick to deny the offence by the police in the interview in front of his father, but then might later plead guilty when confronted with all the evidence and had time to think. The defence solicitor should advise silence, complete silence during the police interview. Not to say you are a very bright lad and you know what to do. No, he's a 13-year-old M suspect. He doesn't know what to do. That's why you are there, Paul Barlow. What should have been said to Jamie is this: Jamie, listen very carefully. Sit down, head down, don't say a word. Do you understand me, Jamie? 9. The defence solicitor does not properly explain and advise what the appropriate adult should and should not do during the police interview, and in fact gives the green light for the father to speak up. Just be yourself, he tells the father at one point, and boy, did he mess things up for Jamie. 10. The police interview. Where do I start with the mistakes this criminal defence lawyer made? Because it gets worse. Jamie's defence solicitor is told where to sit, and he sits in the worst position behind Jamie. Even though rightly, this lawyer told Jamie, if he's unsure, just look to me. Remember that no comment. There is no law or police power to dictate where the solicitor sits in a police interview room. So the defence solicitor should never sit behind their client. A lawyer, solicitor, should sit where they can see their client's face and the face of the police. Jamie's solicitor should have sat at the head of the table, like being the chairman of the board or the godfather of meeting his subordinates, in a commanding position, not behind his client in the corner. 11. The defence solicitor makes no opening statement at the beginning of the interview like this: Officer, my role is to protect and advance my client's interests. So there is no room for doubt. I will intervene if my client asks for legal advice, or you refer to evidence not disclosed to me, or you try to put pressure on my client, or I will intervene for a break in the interview if necessary. 12. While the defence solicitor did initially prompt Jamie to say no comment, the defence solicitor did not advise Jamie to continue to say no comment because of the crazy advice he gave to answer some questions, but not those about the events last night. Remember, when the officer asked questions about school reports and taking A-levels and problems at school, or Jamie's friends, or posting images and aggressive comments on Jamie's Instagram, or whether Jamie knew the victim, whether Jamie got on with her, or put forward the leading question. So it probably signed you were like friends, right? Any self-respecting criminal defence solicitor would have intervened and said this: Jamie, I'm now advising you to say no comment. The time when the defence solicitor intervened rightly was when he says careful in response to the interviewing officer expressing an opinion that he thinks Jamie knows the victim is D. 13. When Jamie's father advised his son to answer police questions, the defence solicitor should have intervened again straight away. Go ahead, tell them, the father says, which was a police question about naming Jamie's friends. Jamie, I'm now advising you to say no comment, should have again been the response. 14. While the criminal defence solicitor does not have the power to stop the police interview, the defence solicitor should have been much stronger in insisting stopping the police interview when new evidence previously undisclosed to him by the police officer was being referred to, that is, the CCTV footage and images. He did ask the interview to be stopped so a private consultation could take place, but he did it so meekly and so quietly. I insist, he said, but he didn't put that representation strong enough, and he should have further insisted to the father that the interview should be stopped when the father asked for the interview to continue. Look, officer, you have now introduced new evidence not previously disclosed to me. I now make representation to stop the interview to take further instructions from my client. Jamie, if the police insist that the interview continues, I'm now advising you to say no comment. And Mr. Miller, listen to my advice. I'm advising the police to stop the police interview. 15. When Jamie was asked by the officer, why were you following the victim? And the father says, answer the question, son. Again, the defence solicitor should have intervened. Jamie, I'm now advising you to say no comment. Mr. Miller, I'm now advising your son to say no comment. And 16, when the footage was shown of the incident and Jamie becomes emotional and the police continue their questioning, the defence solicitor should have insisted again in stopping the interview. At this point, Jamie is not in a fit state to understand the questions or in a fit state to answer police questions. I want to end by saying this. As a drama, this was close to perfection. The acting was amazing. And the underlying theme of harmful culture that young boys are exposed to is a really serious message and one that society needs to address. But the solicitor's conduct was far from perfect. Thank you for watching. Feel free to comment and don't forget to subscribe and follow for more.